Looks like everyone is here and we can go ahead and get started. Good afternoon, everyone. Before we go on the record, I'm going to go over a few introductory items and then we can get started. Let's see. As you are aware, these proceedings are being live streamed to the public and the live stream has started already. Therefore, make sure that you don't show any personal or private items on the screen. Please also make sure that you silence your cell phones and your laptop keyboards. So good afternoon and welcome to the Office of Tax Appeals. We are here today in the appeal of Belgarde, OTA case number 2307-13903. I am Judge Ralston and I'm the lead ALJ on this panel. Judge Aldridge and Judge Long are the other members of this panel. We also have our hearing reporter, Ms. Alonso. She is present and reporting this hearing verbatim. So to ensure that we have an accurate record, we ask that each person speaks one at a time and avoid speaking over one another. Even if you think that you know the answer to the question, please let the speaker finish first. Also speak clearly and loudly. When needed, Ms. Alonso or any panel member will interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. This hearing, as I mentioned, is being transcribed and also recorded electronically. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. Does anyone have any questions before we go on the record? Doesn't look like any, so we will go ahead and proceed. Panel members and Ms. Alonso. Mr. Borbeau, you can unmute your microphone and go ahead.
Thank you. So just a technical question. I don't see anyone else appearing at this point as far as the parties except for me. Am I just not seeing the other parties, or is there a technical issue?
It looks like you might have a technical issue on my end. I can see the panel members, the court stenographer, your witnesses, as well as the representatives from CDTFA and DU. Do you want to pause for a minute before we go on the record?
No, and I apologize. Now I see Judge Long, Judge Aldridge, and Ms. Alonso. Thank you.
Okay, great. Okay. We are now on the record in the case of R. Belgarde, OTA case number 2307-13903. The date is August 18th, 2026, and the time is approximately 1:08 p.m. This hearing is being held electronically with the agreement of the parties. I am Judge Ralston. I am the lead ALJ for this panel. My co-panelists are Judge Aldridge and Judge Long, and we are all equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to introduce themselves and who they represent, starting with Mr. Borbeau.
Yes, Your Honor. James Borbeau, representing Rick Belgarde, the appellant. And if I may, ask another housekeeping question. Mr.
Sure.
Belgarde is the duelee. He is going to attend the entire hearing, correct? I don't see him on the screen. He's a witness, but he's also the taxpayer. So just a technical question. I'm not sure how the OTA proceeds in this way. I've not done a video hearing before the.
Yes, it may be that you aren't seeing everyone. It depends on the way your teams are set up. You might need to scroll a bit because Mr. Belgarde is here. I can see him on my screen as well as Mr. Prasad.
Okay, thank you. I don't see anybody there. Thank you.
Sure. At the bottom, it usually says like participants. And if you click on that, you may be able to change the way your screen is set up. And that way you may be able to see everyone.
Thank you.
Sure.
And I do see a number of other people listed on the participants. So I apologize. They're just not coming up on my screen. So I wasn't sure if they're in the room. Thank you.
Sure, no worries. Looks like everyone is here that I am aware that is supposed to be here. So let's continue. So Mr. Bourbeau has introduced himself, and for CDTFA, if you could introduce yourselves and who you represent for the record. Thank you.
Vanessa Bedford, Attorney 3 for CDTFA.
Thank you.
Chad Backus, attorney with CDTFA.
Thank you.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Okay, thank you. So we held a pre-hearing conference in this matter on July 20th, 2026. And as discussed at the PHC, the issue to be decided in this appeal is whether the appellant is personally liable for the unpaid liabilities of WDFA under Revenue and Taxation Code 6829. Mr. Bourbeau, do you agree that this is the issue?
I do, Your Honor. Thank you. I agree.
Thank you. And Ms. Bedford, do you agree that this is the issue?
We do, Your Honor. Thank you.
Thank you. So at the pre-hearing conference, appellant submitted exhibits 1 through 8, and CDTFA submitted exhibits A through F. Neither party noted any objections to these exhibits at the pre-hearing conference, but I'm going to ask again, Mr. Bourbeau, do you have any objections to respondents' exhibits A through F?
No, Your Honor.
Thank you. And Ms. Bedford, do you have any objections to appellant's exhibits 1 through 8?
No, we do not.
Okay. Okay, thank you. So appellant's exhibits 1 through 8 and respondent's exhibits A through F are admitted without objection. Also, you may have noticed that on our panel, Judge Aldridge is substituting for Judge Ridenhour. Mr. Bourbeau, did you have any objections to Judge Aldridge substituting for Judge Ridenhour?
No, Your Honor, none.
Thank you. And Ms. Bedford, did you have any objections to Judge Aldridge substituting for Judge Ridenhour?
No, we do not.
Thank you. At the pre-hearing conference, Mr. Bourbeau, you stated that you would have Mr. Belgarde and Mr. Prasad as witnesses. Is that still the case?
Yes, Your Honor.
Okay. And looks like both witnesses have signed in. Ms. Bedford, did you have any objections to either witness testifying?
No, we do not.
Thank you. We are ready to move on to the opening presentations. Mr. Bourbeau, you requested 105 minutes for your presentation and witness testimony. After your witnesses testify, CDTFA may have questions for your witnesses, as well as the panel members may have questions for yourself or the witnesses. And Ms. Bedford, you have requested 20 minutes for your presentation. And then after respondent's presentation, Mr. Bourbeau, you will have about 10 minutes for rebuttal. Does anyone have any questions before we move on to the presentation?
No, Your Honor.
Okay, and Ms. Bedford is indicating no as well. So I'm going to swear the witnesses in before your presentation. And then, Mr. Bourbeau, it's up to you how you want to structure your presentation. You can give your presentation and then have your witnesses testify, or you can start with your witnesses, however you would like. And you can ask your witnesses questions, or they can testify in a narrative fashion, however you like. The time is yours to use how you want. But before we begin, I'm going to ask Mr. Belgarde and Mr. Prasad to please raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes,
Okay. And
I do.
thank you. So, Mr. Borbeau, you may begin when you are ready.
Very good. Thank you, Your Honor. I'll start with my opening statement because that is how I understood the proceeding to go forward, and it's drafted in that way. So if it pleases the panel, I'll go ahead. Thank you. Esteemed members of the panel, Richard Joseph Belgarde appears before you today for one reason only: to clear his name. The dual determination against him is $15,744.91. He has already spent more than $61,000 in legal fees fighting it. When counsel repeatedly told Mr. Belgarde the economics made no sense, his answer never changed. He said, quote, "I was not there. I did not do this. I will clear my name," end quote. In nearly 20 years of practice, this attorney has never seen a client so willing to spend his own money solely to erase an erroneous tax determination. That's not usually what I do. Usually I'm trying to save my clients money. Here, that ship has sailed. That single fact should tell this panel everything it needs to know about the truth of his position. However, we will go into the merits of our position as well. First, Mr. Belgarde was not a responsible person for WDFA Ventures 2 LLC, the taxpayer in the underlying assessment, during the liability period of January 1, 2011 through January 22, 2012. He completely departed the company by the end of September 2010, and he has said so from the very first department contact. On April 16, 2014, investigator Luis Villasenor recorded Mr. Belgarde's statement in the ACMS notes, Appellant's Exhibit 2, dual package, ACMS notes, approximately PDF of the appellant's brief at pages 22 through 24. He started, and this is Mr. Villasenor's quoted language from his determination. He, meaning Mr. Belgarde, started to leave the company in April 2010 and went completely away in September 2010. Those are recited, you'll see from the record, those are recitations of Mr. Belgarde's statement to Mr. Villasenor. Mr. Belgarde has never wavered. He will testify to that fact under oath today, subject to cross-examination. The department's 2014 statements identifying Mr. Belgarde as the responsible person are classic multiple hearsay. They consist of out-of-court statements by Jason Hilton, Ryan Ogden, Stephanie Shen, and Mr. Raj Prasad, who is testifying today, and who, unlike any of the department's declarants, will in fact appear today subject to cross-examination to support those statements. These hearsay statements were filtered through Mr. Villasenor's ACMS notes and then summarized in the dual memorandum, all offered for the truth of the matter asserted. None of these declarants are appearing today. None will be subject to cross-examination. None of the statements were made under oath. As the panel is undoubtedly aware, we even gave the department an opportunity to put on Mr. Villasenor to support his hearsay statements, and they declined, or rather opposed our request for subpoena, which in the end is itself revealing. Nobody is here today on behalf of the department except the hearsay and the lawyers. Even if the department were to put on someone, it's apparently not going to be the declarants. This would not fly in a court of law. In fact, the IRS and EDD payroll tax responsibility analogs are never rendered in this way. In an IRS hearing, first of all, estimates are not applied toward responsible persons. These are unpaid taxes that were reported and went unpaid. And in an IRS or EDD hearing, the declarants always sit before the ALJs or the tax court judges and support their hearsay statements. Under Regulation 30214 sub F4, the panel may use the California Rules of Evidence when evaluating the weight of any evidence. In appeal of Todd A. Welker, 2019 OTA 247, non-precedential, but we offer it here as persuasive, if not binding. The panel expressly invoked that regulation and held. The opinion notes that the statement to the escrow officer was hearsay. Regardless, we did not exclude the evidence. So what we hear there is obviously hearsay can be admitted. However, the panel goes on. Quote, the panel is allowed to use California rules of evidence when determining the weight to be given to evidence. And we gave all evidence the weight to which it is entitled, period. End quote. So the same principle applies here. Because the declarants are absent, the statements lack every reliability safeguard, oath, cross-examination, and personal knowledge of the liability period. Regulation 30214 further provides that a factual finding on a material disputed fact shall not be based solely on unsworn statements. The panel should therefore assign these hearsay notes and summaries very little weight. And I add again, this doesn't happen before other adjudicative bodies, such as the California Unemployment Insurance Appeals Board for payroll taxes, nor the IRS for its TFRP, which is trust fund recovery penalties, which is an analog personal responsibility statute and corresponding regulations used in much the same way as Section 6829 and Regulation 1702.5 is here. It just doesn't happen, except here. From the very first moment, investigator Villaseñor contacted Richard Belgarde on April 16, 2014, Mr. Belgarde told the department exactly what he has told every decision maker since. He started to leave the company in April 2010 and went completely away in September 2010. That contemporaneous statement made before any dual determination was issued, before counsel was retained, and before any motive to fabricate could conceivably exist, has never changed. It is the single most important piece of evidence in this case on the question of responsible person status and willfulness. Mr. Prasad, one of the remaining principals, will corroborate this under oath. Unlike the other hearsay declarants, he will today testify to the veracity and context of his hearsay statements that have been made in the record. Mr. Prasad's notarized letter of August 26, 2015 states under penalty of perjury, quote, as of September 2010, Rick J. Belgarde was not a member nor an officer of WDFA. Mr. Belgarde should not be held liable for any debt due by WDFA on or after September 10. The department's contrary hearsay evidence falls into three weak categories. First, documents dated before the September 10 departure. These would be the seller's permit application, SOS, Secretary of State filings, and Quizno applications. These are all in the filings. These prove only what Mr. Belgarde has never disputed. That is that he was once involved. Then 2 checks were offered as exhibits in Mr. Villasenor's dual memorandum. Those are number 116 dated July 1, 2011, and number 1187 dated July 28, 2011, whose signature Mr. Belgarde has always maintained are forgeries, or at best signed by someone else on his behalf. I would point to those exhibits and ask that the panel take a look at Mr. Belgarde's signature, which consists of a series of basically of loops. Unfortunately for him in this case, anyone, including myself, the department, and the panel, could make that signature. It is actually a series of loops. In fact, at great cost to Mr. Belgarde, a forensic handwriting specialist could not say for certain these checks were signed by him. The report was inconclusive either way, admittedly, but I think it's very important that this very well-esteemed handwriting expert who testifies regularly in court couldn't make that determination. In other words, anybody can make a series of loops on a check. And I move on to the 2014 hearsay statements from employees and investors that never placed him in the business during the actual liability period. Contrast that with Mr. Belgarde's conduct on the companion duel for Job Ventures, Inc. He conceded responsibility for that overlapping period because he was actually there. You'll see in the record, esteemed panel, that this is a completely different duel, but it is a duel that placed Mr. Belgarde in that section 6829 role as responsible person. Mr. Belgarde ceded that assessment. That assessment has been paid. He will admit today under oath that he was the responsible person in that case, just not WDFA Ventures 2 LLC, the entity at issue today. Now, moving on to our second position, even if the panel somehow found him responsible, the entire board assessed estimated portion of the duel must be stricken. Regulation 1702.5 is unambiguous. Personal liability attaches only if the entity, quote, collected sales tax reimbursement and failed to remit such tax when due, end quote. Such tax means the specific tax the department now seeks to duel. The department's only proof of collection for the estimated periods consists of 4 hearsay and, as of today, unsupported 2014 statements that sales tax was charged and collected. And this is a general statement. This happens a lot in my experience in these types of estimated assessments that are then dueled. The department's only proof of collection, none of these statements identify a single dollar collected in the estimated periods. That is not proof by a preponderance that such tax was collected. The department's response brief claims appellant conceded collection throughout the liability period. That claim is false. I don't find that in the record. I'm not sure what that claim is based upon, but we understand that claim to be inaccurate. Mr. Belgarde's own May 23, 2014 business operations questionnaire, which is in the record, he checked, I don't know, to whether sales tax was collected. He could not know. He was not there. Third, there was no willfulness. A man who left in September 2010 cannot have had actual knowledge of estimated liabilities manufactured years later for periods when he was gone. This is fundamental to the point of being somewhat aggravating. So part of this statute requires willfulness. Mr. Belgarde will testify today that he wasn't there. Therefore, that prong necessarily fails if this panel finds that Mr. Belgarde was indeed not there, and his testimony and that of Mr. Prasad is credible and compelling. It would be impossible for him to act willfully. Finally, I want to ask the panel to do something which is probably outside of its comfort zone, but well within its role in legal, factual, and statutory interpretation and its mission. Consider the dispositive legislative history which undergirds Section 6829. I spent the time to comb through the microfiche and the boxes of documents from 1981, Thomas Hannigan, who was the author of what is now Section 6829. Our position in this regard is completely fleshed out in the writings, but I want to stress it. I think it's very important. First of all, the California Supreme Court has instructed that the primary purpose in construing a statute is to ascertain and give effect to the legislature's intent, and that the plain language is the best gauge of that intent. However, if the plain language eludes the panel, we implore you to read this legislative history. It is stunning. That's my opinion. It is stunning how obvious it is that, for instance, the author's August 27, 1981 letter and the board's own, this is coming from the board's own September 8, 1981 letter, both require that the BOE had, quote, collected the tax, end quote, and that such taxes have in fact been collected from consumers, end quote. I'm stunned at what has happened at the department. I've looked back, and the farthest I can find is 1991 in the records possessed by the department. That's where it ends. But that is a gap of 10 years. And so between 1981 and 1991, which is about where I first find this idea that in the policy manuals that the board at that time and the department now can make a finding of tax reimbursement allegedly, according to hearsay, being collected through statements and then estimated from records, understandably. I mean, look, I get it. I need to say, actually, this issue has become a mission for me. And it's because I think this is wrong. I think it's just wrongly applied. Somewhere along the line, the BOE and then the department was able to insert language in its own policy. And we'll talk about that later, soon, I promise. We'll talk about Madfish and the idea that policy can be law. This board has already ruled that policy cannot be law. And so I think that legislative intent is much stronger than the post-1991 department policy. So what I was going to say, actually, is I've worked with the department and the BOE for a number of years, and I find them to be ultimately very reasonable in how they go about their work, except in this one way. It is, again, stunning to me that if you read the legislative history, it's so clear. This law was introduced, passed and chaptered by Governor Brown for the sole purpose of going after those bad acting CEOs, accountants, presidents, etc., those responsible people who filled their own coffers with actual money that they had collected and then absconded with it. And so the law was necessary. Like I said, there's an analog in payroll taxes, both where it concerns the IRS and the EDD, but this is just incorrectly processed, promulgated, assessed. It's not right. In fact, the Senate analysis, which is included in the record, described the precise evil: individuals who pocket sales tax that was actually collected. What the department has been doing, and I understand it, there's institutional creep. The department, I think in many cases, rightfully so, understands these taxes to have been collected. I think the problem facing the panel and anyone looking at this is, were they collected? And what happened between 1981 and 1991, where this very strong legislative intent was watered down to mean just some sales tax reimbursement was collected by someone at some time? I think it's too vague. And I'm actually, I can't wait until one of these goes to court, because I think we'll prevail. And I ask the panel, please put aside the institutional history and look at the statute. This is going to come up again. It's already in the pipeline before this body in a number of my cases. It keeps me awake at night. It actually does. And not much does that. Okay, I've been doing this for a few years. This one really bugs me. And I think that we need to turn it around. And so where it comes to estimated assessments, at least, even if you find that Mr. Belgarde was there, which he was not, I asked the board to take a very close look at the legislative history. To me, it's clear. As I say, this panel has already rejected precisely this kind of agency overreach, meaning the OTA in Madfish ruled decisively that the CDTFA's internal policy could not control over the plain language of the statute at issue in that case. We ask that the board please review and apply Madfish in this case as well. Finally, Mr. Belgarde is not asking for sympathy. He is asking this panel to apply the statute as passed and written, and to consider that this man, at great personal expense, like I said, I've never seen anything like this in my entire career, where a person has paid 4 times the assessed amount to clear his name. We implore you to hear Mr. Belgarde's and Mr. Prasad's testimony in this regard. He was not there. The hearing, I'm sorry, the dual determination should be reversed in full. At absolute minimum, the entire estimated portion must be stricken. Mr. Belgarde is here to clear his name. We ask that the panel grant him this. Thank you.
Okay, thank you, Mr. Borbeau. You can move into your witness testimony now if you'd like.
Thank you. I call Richard Belgarde, please.
All right. Just in case you can't see me, I am here.
We can see you, Rick. Good afternoon.
Good afternoon.
Thank you for being here.
My pleasure.
Mr. Belgarde, please state your full name and current residence for the record. Or
Richard,
rather, sorry. Feel free to just state your name. This is going live on YouTube, so we don't need to have your address. I apologize.
Richard Joseph Belgarde. I go by Rick Belgarde.
Thank you. Are you the same Richard Joseph Belgarde who is the appellant in OTA case number 230713903, which is being heard today?
Yes.
When did you first retain me in this matter?
On or around November 2015.
And approximately how much have you spent in legal fees defending this dual determination?
61,000 and counting.
The amount at issue is approximately $15,744. Why have you continued this appeal despite the cost exceeding the liability many times over?
It's very important that I do clear my name because I was not there during the time period in which the board has said that I was. And I don't mind paying for things that I was there for, but I was not there and I have no reason to lie.
Have I indicated to you in the past that this doesn't make financial sense to go forward?
You said it the first time I met,
I believe that's
10 years ago plus.
Thank you.
You made it very clear that this was not a good financial decision.
Okay. Part of my job. Okay. Have you ever wavered in your statement that you completely left WDFA Ventures 2 LLC by the end of September 2010?
No.
Why did you leave?
Um, this is the gentleman who's here who will testify. We had a bit of a disagreement on how to run the company. I wanted to lay off a bit more people than he did, and I just thought that would be part of the downfall of the company if we didn't do that. And I thought, since I only own 2% of the company, I should let Raj run the company how he wants. And we were just fighting a lot, the two of us. And I just thought at that time it would be best if, let Raj do what he wanted to do in regards to the company. And I was going to stand down and stop fighting with him at that point.
When you left in September 2010, did that departure include your complete separation from the company WDFA Marketing Inc.?
Yes.
And what did WDFA Marketing Inc. have any role in the entity at issue today, WDFA Ventures 2 LLC?
Yes, they owned the entity. It was a single member LLC, which is a discredited entity for the IRS. And the managing member is WDFA Marketing.
So WDFA Marketing Inc. is the managing member of WDFA Ventures 2 LLC, or rather
That's correct.
was at the time.
Yes. Yeah.
If you were no longer, meaning after September 2010, an officer, director, or affiliated with the managing member entity, did you retain any authority or control over the managed entity, WDFA Ventures 2 LLC?
No, including making payments.
After September 2010, did you ever set foot in the Quiznos Placerville location or participate in any management decision?
I will even go far back as the purchase of it. I never had been in the location ever.
So do you disagree with any statements that were made in the record that would have placed you as a direct operating manager in those stores of any kind?
I was never in the stores whatsoever. There's no way. No officer or whatever at the company had ever stepped in to any of those locations whatsoever.
Quiznos was a sandwich store, correct?
Yes, that's correct.
After September 2010, did you have any access to the business checking account, books, records, or POS system of WDFA Ventures 2 LLC?
No.
Did you file or cause to be filed any sales and use tax returns for any period after fourth quarter 2010?
No.
Were you even aware that sales and use tax returns were due or filed for any period after fourth quarter 2010?
Was not a part of it. I don't know what they did.
Describe your role with WDFA Ventures 2 LLC and its related entity, WDFA Marketing Inc., prior to September 2010.
I was the CFO of the company, and in turn, I oversaw the different entities that were underneath that, which is also WDFA 2 or whatever it's called for it. And during that time period, I was responsible for anything financial during that time
Now,
up until my departure.
I apologize. Thank you.
Yeah.
Mr. Belgarde, I'm directing your attention to a document that was used as an exhibit in the dual determination memorandum. That is the December 11, 2009 California Secretary of State limited liability articles of organization. Are you able to access that document where you are?
Yes, I think I have it in front of me.
Are you familiar with this document?
Yes. I am familiar with it. I did not do anything to change it because I was no longer with the company. That would have been somebody else's responsibility.
And this document dated in 09 would be before your departure, as you've stated, correct?
That's correct. Yes.
And then afterward,
That's the lawyer who set it up for us, but go ahead.
I see. Who is the lawyer?
The one who signed the document, Christian Howe.
Okay. It names you as agent for service of process, correct?
Mhm.
Yes. But
Yeah.
again, this is 2009 when you were actively in the company, correct?
That is correct.
Did that fight? Oh, sorry. Sorry, strike that panel. I apologize. Is that sorry, if I could, a point of clarity before the board, if I may, Judge Ralston.
Sure.
Thank you. So I referred Mr. Belgarde to the December 11, 2009 Articles of Organization. I had meant to show Mr. Belgarde actually the statement of information made in, pardon me, I apologize. January 28, 2010. And so that is my mistake. The January 2010 statement of information was included in the dual package, but I'm seeing here, I have questions about that, and I did not provide that to Mr. Belgarde. And so I would like to ask him some questions about that, but I'll just refer to that statement of information as if it, understanding that it is in the record, the panel can access it, but I'll just ask Mr. Belgarde general questions about the date, if that's allowable.
Yeah, that's fine.
And I apologize. That's my mistake. I also meant to give him the statement of information. Mr. Belgarde, if there is a statement of information in the record dated January 2010, would that also be filed while during your tenure with WDFA Ventures 2 LLC?
Can you ask that again? The
Yes,
internet
sorry.
went out for a minute.
I'm sorry, January 28, 2010. That is the date that the department has offered a record. It is a Secretary of State statement of information for WDFA Ventures 2 LLC, January 28, 2010. Was not that record also filed during your actual tenure?
Yes.
And would you have any idea if that was ever corrected upon your departure in September 2010?
I have no idea. I never checked.
Okay, thank you. I apologize, panel. That is my mistake in not getting Mr. Belgarde the second document. Who after you left had access to the check stock and authority to sign or cause signatures on WDFA Ventures 2 LLC checks?
I believe it was, I'm not really sure, but I can tell you who had availability when I was there. It was Jason Hilton and myself and Stephanie Shen. She wasn't a signer, but she had access to it. At no point did the man that's in this here have access to any of that. He never signed any checks or even knew where the stock was.
Thank you. In a separate dual determination involving Job Ventures Inc., account 101-720382 for overlapping periods, did you concede responsibility?
Yes,
Was Job Ventures Inc. a company related to WDFA Ventures 2 LLC?
not at all.
Why did you concede the dual determination regarding Job Ventures, but not this one?
Because I was around during that particular time and I was the responsible party. I was one of the responsible parties.
On your business operations questionnaire dated May 23, 2014, on question 1, was sales tax reimbursement collected from customers? You checked, I don't know. Was that your true answer at the time?
It's still my true answer today. I don't know.
Did you even know after September 2010 whether the business was still operating or what its daily sales might be?
No,
Could you have caused any payments to be made from the LLC's accounts after you left?
no, I didn't have checks or anything to pay anything.
Are you familiar with the document, the two copies of checks in the department's dual memorandum? One is a WDFA Ventures 2 LLC check number 1166 dated July 1, what I guess appears to be 2011, but the copy is unclear. I think it was offered by the department as an exhibit in its dual as that date, 7/1/2011, and then check number 1187 dated 7/28/2011. I believe I've I've provided these two copies to you. Have you had a chance to review them?
Yes, and I've seen them before because during another hearing or what have you, they showed it to me.
Thank
Yes.
you.
Mhm.
Is this your signature on either of these checks?
I wasn't around to sign those checks, so no.
Do you suspect they might be signed by someone else using a facsimile of your signature?
Yes, you can just look at my signature and start doing exactly the same thing.
Did you not, in fact, pay quite a sum for the handwriting expert to review these checks as opposed to your genuine signature? And was that conclusion, what was that conclusion?
I indeed paid a handwriting analysis person to look over it, and the person concluded it was unconclusive, that they could not determine that it was my signature and it was not my signature.
Thank you. So moving to the 2014 hearsay statements by Jason Hilton, and these are the hearsay statements that the department has included in its dual memorandum and its briefing since and its determinations. Did any of these four people, Jason Hilton, Ms. Shen, and sorry, bear with me. Panel, if I may, I'm just looking for the witness list. I'm not recalling one of the declarants' names, and I do have it right here. Okay. So those declarants would have been Jason Hilton, Stephanie Shen, and I apologize, Raj Prasad, who's here to testify today. But regarding Jason Hilton and Stephanie Shen, would they have had any knowledge of your having any responsibility after September 2010?
They would know that I was not responsible. So just the two you talked about, they would know I'm not responsible. Stephanie Shen worked for me. And then when I decided not to work there anymore, she went over and started working for WDFA with one other of my employees. And she most certainly knew what was going on. I believe she was the county manager. I'm not sure what her real title was for it, but she would have been working very closely with Jason,
Thank you.
not Raj.
Thank you. From the first telephone call with investigator Mr. Villasenor on April 16, 2014, what did you tell the department about when you left WDFA Ventures 2 LLC?
I told him I left at the same time as I left WDFA marketing.
Is that statement true today, just as it was true on April 16, 2014?
Yes. Yes.
Has that statement about your complete departure by the end of September 2010 ever changed in the 12 years since you first made it to the department?
No, sorry for interrupting.
No problem. Thank you. Why should the panel believe you over the department's later documentary inferences drawn from the documents that predate your departure?
I would go with the fact that why would I spend $61,000 to clear my name for? The fact is I do accounting for a living, and I need people to understand, my clients or whomever out there, that I'm honest. And this is including the uh, any agency out there. I have no reason to lie to them nor to anybody else for it. I built my business on the fact that I am responsible when I take on those responsibilities. I also have no reason to lie to anyone in regards to it. Otherwise, I wouldn't spend 61,000 plus to go ahead and defend my, it sounds weird, honor. To be quite honest, I just will go to the end with this until I can't go anymore, to prove my innocence.
Thank you, Mr. Belgarde. No further questions, Your Honors. We reserve the right to redirect. Thank you.
Okay, I'm going to pause your time for a minute and check with the department to see if they have any questions for Mr. Belgarde.
No, we do not.
Thank you. And let me check with my panel members. Judge Aldridge, did you have any questions for Mr. Belgarde?
Hi, this is Judge Aldrich. I do have a quick question for Mr. Belgarde. With respect to the 2% ownership interest that was referenced, is that in the, um, I guess, which business entity was that ownership interest in?
WDFA marketing, and all of the underlying, the entity that's in question today was a single member LLC that was owned by WDFA marketing.
Okay, so in a sense, you had an ownership interest in the current business.
I had through that, yes.
Right. Okay.
Yes.
And upon your departure, did your ownership interest change? Was it sold? Was it?
Was not sold. Nothing was done of it. Unfortunately, a year after my departure, WDFA marketing went into bankruptcy protection, and they went out of business at that point. So there wasn't anything from Raj or anybody there saying they were going to buy out my interest at that time. So and I think I'd also, if you don't mind, you didn't ask me this particular question for it. I actually personally guaranteed the building that they had, and I paid out money associated with that when they went out of business. So I took responsibility for what I had to take responsibility for, because that's what I did at that time, because I promised that at the very beginning when we got that building. And so there was a payout that needed to happen, and I paid it out of my own personal funds. And that's just what's really important to me. I did own 2%, but at that time, I was no longer a member of the company. I didn't do any voting on anything. I was a silent partner at that point, of which that was fine with me with it, because I wanted Raj to be successful.
Thank you.
Yeah.
Back to Judge Ralston.
Okay, thank you, Judge Aldridge. Mr. Belgarde, you stated that you had started to leave the company in around, I think you said like around April, but it took until September for you to be fully separated. What actions were you taking to leave the company? Did you notify people or send any emails saying, hey, I'm no longer involved? Is there any kind of documentation?
Raj and I had a conversation, and we needed the correct transition for me to be out. So I didn't want the business to fail, just because I was leaving and all the accounting staff reported to me. So we figured out a solution together to help transition it as smoothly as possible, so there was little disruption to the business.
Okay, and this was all oral, not written.
Yeah, Raj and I used to talk, almost every single day about things, and we've always been very direct with each other and honest about what was going on. So yeah, we didn't communicate through email. That's not our style, to be quite honest. We like to talk to people on the phone.
Okay. And before that April date, when you were a part of the business, you had the check signing authority. Were you the person that would pay, the electric bill or the rent, any type of bills for the corporation, or you just had signing ability but weren't the actual person to pay the bills?
No, I signed everything. That no one else, when I was there, no one else signed anything in regards to it. What happened after that, I don't know, to be quite honest. But when I was there, no one else signed anything. Everything came through me. I made sure that we had proper approvals, and also it matched up against whatever needed to happen. And then I signed the checks and we sent them out. So when I was there, I was the only signer. Unless I was on vacation or something, then I don't think we really signed many checks when it was gone.
Okay. And were there others that had the check signing authority?
All four people who owned part of WDFA marketing, which included Raj, Jason, and Andy.
Okay. And then when you left, did you file anything like with the bank to take your name off the accounts or anything?
First of all, I can't file anything. They have to file it to get me off. So I don't know if they got me off or not. I do know that I don't think they followed proper procedure and take me off immediately.
Okay, thank you. I don't have any further questions. I don't think my co-panelists do. We may ask you some questions after after Mr. Prasad and Mr. Borbo wrap up, or after CDTFA does their presentation. But I think for now, we have no further questions. So Mr. Borbo, back to you to continue your presentation.
Thank you. I'll ask the panel to please call Mr. Prasad at this time.
Yes, Mr. Prasad, you are up.
Hello.
Good afternoon, Mr. Prasad.
Good.
It's nice to meet you. Finally, I've spoken with you through emails, and I've seen your name for the past 12 years. But it's nice to thank you for appearing, and it's nice to meet you. Please state your full name, sir.
Rajneel Prasad.
What was your relationship to Rick Belgarde in 2009 through 2010?
He was our CFO, shareholder, and member of our board of directors.
What was your role with WDFA Marketing Inc. during this period?
I was the CEO, with my primary function being revenue generation.
And with WDFA Ventures 2 LLC, the taxpayer entity at issue today?
I had no role with that organization at all. It was about 3 or 4 people away from me in terms of operations or anything. My only involvement with that business would have been I would create marketing strategy that we would test out on that business, and then I would try to go sell it to the corporation or other franchises.
Thank you. By the end of September 2010, had Rick Belgarde completely left both WDFA Marketing Inc. and WDFA Ventures 2 LLC, meaning he was no longer a board member, officer, manager, CFO, or with any authority over either entity?
That is correct.
And I'm turning your attention to a statement you made in August of 2015. It is on WDFA marketing letterhead. Are you in possession of that document today?
Yes.
Are you familiar with this document?
Yes.
Okay. When you, and I believe it says as of September 2010, or I'm reciting it. I'll ask you if this is accurate. As of September 2010, Rick J. Belgarde was not a board member or an officer of WDFA. Mr. Belgarde should not be held liable for any debt due by WDFA on or after September 2010. Is that an accurate statement?
Yes.
Is it as true when you wrote it in 2015 as it is today?
Yes.
Can you describe the role of WDFA marketing with WDFA Ventures LLC? Sorry, Ventures 2 LLC. What is what are the roles of both companies and how are they interrelated, if at all?
Okay. To be honest, I'm going back like 15 years here, almost 16 years. So I'm trying to be as honest about this as I can. There are some things that are fuzzy. But the original relationship was WDFA marketing would purchase out fire sale franchisees and we would operate them not for profit, but more of a testing ground for marketing campaigns. And then once those campaigns worked, we would scale them up to franchisors, franchisees within that same system, just to kind of make our sales process a little bit easier.
Thank you. And what is a fire sale entity? Franchise.
So in franchisee or even most businesses, sometimes a business is not running and the owner wants to offload it, and you know that the business is running at a loss. And when we looked at that books, and once again, but I'm guessing one of the reasons why we picked up that specific Quiznos was it was losing money because of marketing costs. So we were able to pick it up. I don't remember the exact number, but I remember it was relatively cheap. And keep it running because it had employees and stuff. And then we started testing out marketing campaigns within it. So the fire sale is basically somebody wants to get out really bad and they're willing to take a big loss on it.
It sounds like what I'm hearing is that it's a sort of a rehabilitation of a company that is in trouble. Your company comes in, buys it at a discount, and changes certain things to make it profitable or to sell it. Is that a fair characterization?
Yeah, like a general turnaround.
And prior to September 2010, was Rick a part of this company in the CFO capacity? Was he managing the company in any meaningful way prior to September 2010?
In a super meaningful way. Rick had all the payments. He approved all expenses. He managed all of our reporting, all of our taxes. You know, Rick was basically our entire accounting department. Everybody reported to him. Everybody, we were outsourcing from him for a very long time, his employees and his staff and so forth. So, yeah, big part.
Thank you. You've heard Rick testify today to alleged activities after 2010, such as checks being signed ostensibly by him, as alleged by the department. Can you make any meaningful statements about Rick following 2010? In other words, after he says he departed, do you have any knowledge of whether he was involved in these businesses?
Not day to day. No, actually, if I think about it, I mean, if anything, it would just be a call to see where things were. like anytime anybody transitions out of a business, there's that period where you call and, but no, Rick was not involved. And that's, that's the way Rick operates. Once he's done, he's completely out.
And
And
so, oh, sorry, please.
yeah, and I don't remember him going out and me having him involved in anything after that.
Okay, thank you. And in your August 26, 2015 letter, when you refer to WDFA, are you referring to WDFA Marketing as the managing member of WDFA Ventures 2 LLC and to WDFA Ventures 2 LLC? Meaning any reference in this letter to one WDFA wouldn't necessarily mean a reference to both entities.
Yeah, because to me, I know they were structurally different and they were different entities and businesses. But for me, they were just a part of my job at WDFA Marketing, right? So how they were structured or not. So um, while I didn't go into detail in that letter, but yes, once Rick resigned, he resigned from all of it.
Do you personally have any knowledge that would allow you to say whether sales tax reimbursement was collected by WDFA Ventures 2 LLC after September 2010?
I couldn't tell you if it was collected before 2010. I'm the guy you don't let anywhere near money. I make money. You expect me to pay a bill? Well,
Right.
sorry.
Right.
So
Yeah.
yeah, I couldn't.
Okay, thank you. Thank you for your candor. Is there any reason you would have any motive today to falsely exonerate Rick?
No, I was gonna make a joke. That's why I thought. Um, no, not at all. I'm here because telling the truth and being honest matters.
Thank you. No further questions, Your Honor and panel.
Thank you. Ms. Bedford, did you have any questions for Mr. Prasad?
No, we do not.
I have a question. So speaking of paying the bills, after Mr. Belgarde left, who was responsible for writing the checks for the bills?
So it was a transitionary period. We were trying to find a replacement for Rick. My job always was sales, clients, dinners, golfing, just making sure the revenue was filled up. We had an operating team with a COO, director of operations. We had controllers, accounting people. I know I should have a name to give you. But I swear I do not pay attention to how accounting works in the in the companies I run. My job is to make sure the revenue is there, and everybody gets their paychecks. So I'm going to the comfortable statement is the operations team and the accounting team that was there that was put in place after Rick left. But that's where the payments would have been.
Okay. And is there any reason why they would sign Mr. Belgarde's name instead of someone that was on that team?
I couldn't answer that without it being a speculation.
Okay.
I couldn't. This is, by the way, I want to go on the record. This is the first I've ever heard of that. Because Rick and I continued our personal relationship. Rick and I continued working together after WDFA marketing shut down. Rick was not signing checks at that time. He shouldn't have been, because that would have been one of those like, yes, he's a silent investor, but he was no longer on the board. He was no longer an executive in the company. I mean, that would have been a red flag for me because I would have been like, well, what other checks does he have? And is he really siphoning money from the company?
And last question, I know it was a while ago, but do you recall after Mr. Belgarde left, was there any announcement to the employees, how were they notified that he was no longer a part of the business?
So I'm going to preface this. This was 16 years ago now, right? 2010. The world was a little different. So the things that you do now, you send out those email blasts, you update Slack, you put out a press, they didn't exist back then. So a lot of what happened was key people got notified via meetings. It was announced in staff meetings like Rick is no longer responsible for our accounting, no longer our CFO. We're looking for a new CFO. In the meantime, here are these people that you have worked with from CFORick.com who now, or CFO Rick, who now work for us on our payroll. So hopefully there's no breaks in accounting because of this. This was part of the transition that Rick helped us put through, and I smiled because he didn't want to. He didn't want to lose employees, but it was one of those things where it was the best move for our company to kind of bring those people over. So yes, there was a staff meeting. There was an introduction. Were the emails? I'm hoping there were. I mean, I don't have an email to go into and a database to go pull up and say, here's the actual email, but I'm sure vendors were notified. Vendors didn't like Rick. So, you know, so sure we had to notify a few people there. So yeah, there's probably some sort of an announcement that was made.
Okay. What about, did someone keep minutes for the meetings? And would they be stored somewhere?
Yes, we kept meetings for all of our board meetings. Where are they stored today? I couldn't tell you. Like, and I don't mean this in jest, and I don't mean this in any other way. If you knew me personally, you would realize I'm not the paper guy. You don't want any paperwork anywhere near me. It will just pile up. So maybe Jason Hilton has them, but I do not.
Okay, thank you. I'm going to check with my panel. Judge Aldridge, did you have any questions for Mr. Prasad?
I have a couple brief questions for Mr. Prasad. Thank you for being here. With respect to the Quiznos in Placerville, what was the turnaround plan in general?
So the plan usually was if we could pull off a campaign for $1,000 retail, which would cost the company something, I don't know, I forget what our margins were, but it would have cost us probably 50% of that, right? The idea was if we could generate, take $1,000 in advertising and generate 3,000 in sales and show it through the register of that actual Quiznos, we would be able to go to the other 400 franchisees of those Quiznos and go, look at what we did after we bought out the store and ran the tests, and this is what you have to do to implement it.
Okay, and speaking of registers, to your knowledge, did the point of sale system or the register for that Quiznos change at any time 2009 forward?
I wouldn't be privy to that, sir. Like I said, outside of the, hey, we have a Quiznos, we have to market, that was my limitation. The reason why we ended up buying that Quiznos is because when we work with franchisees, sometimes they're not as agreeable as we need them to run the full tests. So the whole idea was we buy it out, we let the incumbent team run it the way it is, and we just put our implementation in, and that way we can run it from start to end without there being any issues. So other than that, I have no idea what, like I said, like Rick said, none of us ever went to that store. It was a geolocation on a map that we used to do targeting for, and then develop advertising campaigns for.
And when you would purchase a franchisee, you were still bound by the franchisee-franchisor relationship that the original franchisee had or had entered into. Is that correct?
Yes.
And do you know if that the Quiznos franchisee was required to have some kind of point of sale system?
Oh, they did.
And were they reporting their sales to the franchisor?
I would assume so, yes, because they were point of sale systems that were connected via network. So um, I didn't go through the franchisee training. I think I was like, great idea. We're getting it for how much? Yes, go get it. I think that's where I'm sorry, that was where my involvement was.
Okay, I appreciate that, and thank you. Back to Judge Ralston.
Thank you. Judge Long, did you have any questions for Mr. Prasad?
Yes, I do. I am looking at the responsible person questionnaire that you filled out, Mr. Prasad, um, on dated April 29th, 2014. It's part of the dual memorandum, which is Exhibit D of CDTFA's briefing. And it specifically asks, if known, provide the name, title, address, and telephone number of any person who had responsibility for the business, sales, and use tax compliance during the time you were working for or associated with the business. And you only identified Mr. Belgarde. And similarly, in a phone conversation with the auditor on April 16th, 2014, you identified Mr. Belgarde as the person that would have any financial information for the company, that you had never seen balance sheets, that he was CFO, and that he ran the day-to-day operations of the business. And then also with respect to your role and Mr. Hilton's role, essentially you had nothing to do with the day-to-day operations of the business. With respect to the sales and use tax responsibility and the ability to make payments for the sales and use tax, I'm having a hard time reconciling your current testimony with these statements. And if Mr. Belgarde didn't have the opportunity to, or the sales and use tax responsibility after the September 2010 date, why you didn't identify another person at the time. Can you kind of give me some idea?
Yeah, absolutely. So the first time I filled out the questionnaire, and once again, we're going back 12 years here, so I'm going to answer to the best of my memory and knowledge. I do remember filling out the questionnaire. At the time, I thought it was for WDFA marketing, because remember, for me, it's all one thing. Like I found out because of this hearing that there was a WDFA Ventures too. That was, so there's a one somewhere was the joke that came out of my mouth. So I at the time, that's what I thought. Then I had my phone conversation with the gentleman, and I was honest, and I would go on record today and say the same thing. While Rick was around, he managed all of it. He's the guy I would have always pointed at during those time frames. Later, I find out that the way I had answered, or maybe I wasn't as clear with Rick's departure, I had to rewrite that statement that you see from 2015. Why did I name somebody else at the time? To be honest with you, I didn't want to accuse somebody of something when I wasn't 100% sure. And I know, being the former CEO of the company, the responsibility does fall on me, and I acknowledge that. But at the same time, this was a massive company at the time. There was 7, 8 people in our accounting department. We had multiple people in our operations department. I legitimately, like, after Rick left, I legitimately couldn't tell you who was making those payments. So that's one of the reasons why I never offered another name, because I'm in kind of the gray area as everybody else.
Okay, thank you. I don't have any other questions.
Thank you, Judge Long. Thank you, Mr. Prasad. The panel has no more questions for you. Mr. Bourbeau, I think you still have a few minutes for your still on your opening, and then we'll move on to CDTFA's presentation, and then you'll have a few minutes to respond. So,
Oh, thank you, Your Honor. I do have a possible redirect question for Mr. Prasad. What I'm looking for now is the wording that Judge Long recited from the questionnaire. I am looking at the department's exhibits right now. I can find it in a minute or two. If you allow
It's
time.
question 6
Question 6 in the dual memo.
of the responsible person
Oh,
questionnaire.
thank you, thank you. And I do have one here. However, if it pleases the panel, I would need to show Mr. Prasad the document. Is there a way that we can have somebody put it up on the screen while I ask my question? If not, it's not the most important thing here today. I think Mr. Prasad's testimony is clear. So I really don't need to make a big thing of it. I just thought, well, I think this also hinges on the wording of the questionnaire itself.
yeah, I'm not aware of how we would put that on the screen for him. I
Okay.
think the only way we would be able to do it is you could email it to him, but we don't, that's the only way that I'm aware of how we could get him the information.
In reviewing it right now, panel, I think I'll avoid asking the question simply because I believe the witness answered the question, and Judge Long, of course, recited the language of number 6 accurately. So I don't think we have need to ask Mr. Prasad any more questions about it. He asked, or he answered the question. Thank you.
Okay, thank you. Does that conclude your presentation?
Reserving the redirect as needed if
Yeah, after
that's available. Yeah.
after respondents presentation, you'll have another chance
Mhm.
to speak. So that concludes your presentation for right now.
Yes, thank you.
Okay, thank you. We are going to take a 10-minute break. Please make sure that you mute yourselves during the break. And it is 2:33. So let's say 12 minutes. Let's come back at 2:45.
Thank you.
You may also want to mute your video. The live stream is still ongoing, but also don't disconnect because we'll have to try to get you back in when we come back. So thank you. I think everyone is back and we can continue. So we are back on the record. It is 2:45, and Miss Bedford, it's time for your presentation, so please begin when you are ready.
To the panel, the department understands the primary issue in this appeal is whether appellant is entitled to a refund of the approximately $15,700 involuntary payment for unpaid sales and use tax liabilities of WDFA Ventures 2 LLC, WDFA, for the liability period January 1, 2011 through January 22nd, 2012. Specifically, if the department proves that appellant is personally liable for the unpaid sales and use tax liabilities of WDFA for the liability period pursuant to Revenue and Taxation Section 6829, appellant will not be entitled to a refund. The department maintains its position that appellant is personally liable pursuant to Section 6829 for the unpaid liabilities of WDFA for the liability period. As you're aware, upon termination, dissolution, or abandonment of an LLC's business, any officer, manager, director, or other person having control or supervision of, or who is charged with the responsibility for, the filing of returns or the payment of tax, or who is under a duty to act for the LLC in complying with any requirement of the sales and use tax law, is personally liable for the LLC's unpaid tax, interest, and penalties if the person willfully failed to pay or caused to be paid any taxes due from the LLC. Section 6829, Subdivision A. See also California Code Regulations, Title 18, Section or Regulation 1702.5, Subdivision A. For an officer to be held personally liable as a responsible person for an LLC's unpaid sales and use tax liabilities, the department must prove the requirements for imposition of personal liability by preponderance of the evidence. Regulation 1702.5, Subdivision D. Effective April 1st, 2017, if the person is not an officer, member, partner, or manager with an ownership interest in the entity, the person is presumed not to be personally liable for the entity's unpaid tax, interest, and penalties, unless the department rebuts this presumption with a clear and convincing evidence. Regulation 1702.5, Subdivision E. Appellant contends that he resigned as an officer of WDFA in September 2010 and was not an officer of WDFA during the liability period. However, there is no evidence to support that assertion. Rather, the evidence shows that appellant resigned from WDFA Marketing, a different business, and is silent on whether appellant resigned from WDFA, Exhibit A, Exhibit 32 at page 15. At the time of the decision, April 2023, WDFA marketing documents available on the Secretary of State's website indicated WDFA Marketing was an advertising agency with 3 corporate officers: Chief Executive Officer Rajneel Prasad, Secretary Jason Hilton, and appellant as Chief Financial Officer. Exhibit A, page 2 at footnote 4. In contrast, there is evidence that appellant was WDFA's sole officer during the liability period. WDFA's January 8, 2010 Statement of Information identified appellant as WDFA's chief and sole officer, Exhibit A, Exhibit 1 at page 2. Appellant identified himself as WDFA's president in its July 6, 2010 permit application, Exhibit A, Exhibit 2. Further, there is evidence of appellant's involvement with WDFA as an officer after the alleged September 2010 resignation. Appellant filed WDFA's 3Q10 and 4Q10 sales and use tax returns, identifying himself therein as its chief financial officer, Exhibit A at Exhibit 3. The EDD wage history and registration information form identifies appellant as WDFA's president for 3Q10 through 2Q11, Exhibit A at Exhibit 6. 2 responsible person questionnaires completed in 2014 by fellow WDFA owners, Mr. Hilton and Mr. Prasad, identify appellant as WDFA's owner/business manager and chief financial officer, respectively. Exhibit A, Exhibits 15 and 16. Because the evidence demonstrates that appellant was an officer of WDFA during the liability period, the presumption set forth in Regulation 1702.5, Subdivision E, for persons who are not officers, members, or managers with an ownership interest, does not apply, and the department need prove each element required by Section 6829 only by a preponderance of the evidence. The 4 elements that must be met to impose personal liability under Section 6829 are: 1, the corporation's business must be terminated, dissolved, or abandoned. 2, the corporation must have collected sales tax reimbursement on its retail sales of tangible personal property and failed to pay it to the department. 3, the person must have been responsible for the filing of returns or the payment of sales and use tax, or under a duty to act for the corporation in complying with the sales and use tax law. And 4, the person's failure to pay the taxes due from the corporation must have been willful. Appellant has conceded that WDFA terminated its business and that WDFA collected sales tax reimbursement on its retail sales of tangible personal property. Exhibit A, page 3 at footnote 5. As to whether appellant was a responsible person, the evidence shows that appellant had control, supervision of, and the responsibility for the filing of returns or the payment of tax, and had a duty to act for the corporation in complying with the sales and use tax law. WDFA's July 6, 2010 seller's permit application, signed by appellant, identifies appellant as WDFA's president, Exhibit A and Exhibit 2. Appellant electronically filed as Chief Financial Officer WDFA's 3Q10 prepayment and 4Q10 sales and use tax returns in October 2010 and January 2011, respectively, which immediately preceded the liability period, Exhibit A at Exhibit 3. Mr. Hilton and Mr. Prasad identified appellant as being an owner and officer, as CFO, and the person responsible for WDFA's financials and sales and use tax compliance, including the filing of its sales and use tax returns and payment of its taxes, as well as the person who was 100% in charge of WDFA's day-to-day operations, who ran the whole thing, and who made financial decisions on behalf of the business. Exhibit A, Exhibits 15 to 20. WDFA accountant and employee Stephanie Shen identified appellant as the person responsible for making financial decisions for WDFA. Exhibit A, Exhibit 24 at page 1. Department records indicate that on 3 occasions in 2014, April 16th, April 17th, and June 19th, appellant agreed that he was the person responsible for WDFA's sales and use tax compliance. Exhibit A, Exhibit 22. Several documents identify appellant as WDFA's Chief Executive Officer and sole officer. Exhibit A, Exhibit 1 at page 2. WDFA is present for 3Q10 through 2Q11, Exhibit A at Exhibit 6, or an officer and/or owner of WDFA, Exhibit A at Exhibits 5, 7, 9, 10, 11, 13, and 14. Additionally, appellant signed 3 of these documents as WDFA's owner, president, or chief financial officer. See Exhibit A, Exhibits 7, 10, and 12. As can be seen, there is documentary evidence up to January 2011 that appellant was a responsible person, and there's no evidence showing that his responsibilities changed after that date. As such, appellant was an owner and officer of WDFA and a person responsible for its sales and use tax matters during the liability period. As to the 4th element of personal liability, the evidence shows that appellant's failure to pay WDFA's tax liabilities was willful. Failure to pay is willful if the person had knowledge that the taxes were not being paid and had the authority and ability to pay the taxes but failed to do so. Failure to pay may be willful, even without bad purpose or motivation. Regulation 1702.5 B2. WDFA's unpaid sales tax liabilities, including tax, interest, and penalties, originate from a self-assessed sales and use tax return for 1Q11 filed late with partial remittance, a notice of determination dated February 28, 2021, issued to WDFA when it failed to file sales and use tax returns for 2Q11 and 3Q11, and a notice of determination. I'm sorry, the date on the first notice of determination is not February 28th, 2021, it's February 20, 2012. And a notice of determination dated October 30th, 2012, issued to WDFA after it failed to file sales and use tax returns for 4Q11 and 1Q12, Exhibit F. Since appellant prepared the 3Q10 and 4Q10 sales and use tax returns, Exhibit A at Exhibit 3, and prepayments, the quarters just before the liability period, and was the only person responsible for WDFA's sales and use tax compliance, appellant had actual knowledge that WDFA owed, but did not timely pay, the taxes at issue at the time the taxes became due, because he knew when the returns and prepayments became due as part of his responsibility to prepare the returns and payments. Because of this background, appellant knew that WDFA failed to timely file its 1Q11 sales and use tax return and failed to timely pay the taxes due. Appellant also knew that WDFA failed to file sales and use tax returns and consequently failed to timely pay its sales taxes. For the remaining portion of the liability period. Additionally, information provided by Stephanie Shen shows that employees provided sales information to appellant, Exhibit A at Exhibit 24. Therefore, appellant had actual knowledge that WDFA made taxable sales and collected sales tax reimbursement, but failed to timely pay the sales tax due on those sales. Based on this evidence, appellant had the requisite knowledge that taxes were due and not being paid as of the dates those taxes were due. Regarding the authority to pay the taxes or to cause them to be paid when the taxes became due, the evidence shows that appellant had that authority. Appellant was WDFA's owner, see Exhibits 9, 14, 15, and 21, CEO and sole officer, see Exhibit A, Exhibit 1 at page 2, President, see Exhibit A, Exhibits 2, 5, 6, 7, 10, and 14, and CFO, see Exhibit A, Exhibits 3, 12, 16, and 23, who submitted payment of WDFA's taxes when he filed WDFA's prepayments and sales and use tax returns for 3Q10 and 4Q10, see Exhibit A, Exhibit 3. Appellant signed 2 WDFA checks during the liability period on July 1st, 2011 and July 28th, 2011, Exhibit A at Exhibits 4 and 8, which shows that he was authorized signer of WDFA's checking account. While appellant alleges that he did not sign these checks, he has failed to offer any evidence that his signatures on these checks were forged. Mr. Hilton and Mr. Prasad identified appellant as being an owner officer and the person responsible for WDFA's financials, including the filing of its sales and use tax returns and payment of its taxes. See Exhibit A, Exhibits 15 to 20. This evidence demonstrates that appellant had the authority to pay or cause to be paid WDFA's taxes on and after the dates those taxes were due as the sole officer, CEO, president, and CFO. This authority is confirmed by the WDFA checks signed by appellant, Exhibit A, Exhibits 4 and 8. As to appellant's ability to pay the taxes, the evidence shows that WDFA had funds available to pay the taxes when they became due, but used those funds to pay other creditors instead. Appellant concedes that WDFA collected sales tax reimbursement during the liability period. Therefore, WDFA had those monies available to pay its taxes but failed to do so. Exhibit A, page 3. The evidence, as summarized in Exhibit A, Exhibit 31, shows that WDFA had funds available during every quarter of the liability period that could have been used to pay its tax liabilities, but were used to pay other creditors instead. For example, WDFA paid its landlord approximately $27,000 in rent payments from 1Q11 through 3Q11, Exhibit A at Exhibit 27. WDFA paid the Quiznos Corporation approximately $29,000 between 1Q11 and 1Q12, Exhibit A at Exhibit 30. Further, WDFA continued operating through January 22nd, 2012, making taxable sales of tangible personal property upon which it collected sales tax reimbursement from customers. The continued operation means that it had sales proceeds available and sales tax reimbursement with which to pay its tax liabilities, but did not do so. In sum, WDFA collected reimbursement through the liability period. Appellant was a responsible person, and appellant's failure to pay WDFA's sales and use tax obligations was willful, meaning appellant had the actual knowledge the taxes were not being paid and had authority and ability to pay the taxes but failed to do so. Based on all the evidence provided, the department has met its burden on each of the elements for imposing personal liability pursuant to Section 6829. For these reasons, we request that the request for refund be denied. Thank you.
Thank you, Ms. Bedford. Does that conclude your presentation?
Yes, it does.
Thank you. I'm going to check with my panel. Judge Aldridge, did you have any questions for Ms. Bedford?
I do have a question for Ms. Bedford. I guess in response to appellant's counsel argument that certain items in evidence are hearsay and should thus be given less weight, do you care to respond to that?
I mean, the OTA regulations 30214 allow the panel to take under evidence any evidence presented, and that includes hearsay evidence. And there's no particular reason that those documents and statements at the time that they were prepared should be given less weight, given the fact that they were prepared and on paper as opposed to in front of the panel today. Mr. Bacchus, do you have anything you want to add to that?
No, I agree. Ultimately, the department understands that it is the panel, one of the panel's jobs, I guess, is to weigh the evidence in front of them. I also don't believe that those documents should be given any less weight. They were, completed many years ago. They weren't completed in anticipation of this hearing. They were just completed in response to questions that were being asked by the department investigating the potential dual liability in this case.
Okay, thank you.
Thank you. Judge Long, did you have any questions for CDTFA?
I do not have any questions. Thank you.
Thank you. Mr. Borbeau, you have about 10 minutes for your rebuttal.
Yeah, thank you. So I'd like to share the department's exhibits and redirect my witness, Mr. Belgarde, if I can, and then I'll.
Mr. Borbeau, let me, sorry, just to interrupt. Just because this is live streamed, I'm not sure which exhibit you want to present, but if you're going to show it on the screen, we just want to make sure it doesn't have any personal addresses, anything like that on there.
I don't think so. It's the department's reply brief.
Oh, okay.
Yeah, so could the OTA share it? Would that be better? It is in the record.
You said it.
It is in the record.
Yes.
So
Okay.
I don't know what is, I guess what I'm asking, Your Honor, is what would convenience the panel more? Should I share it and ask Mr. Belgarde, who, by the way, is somewhat sight impaired, so I'm hoping Rick can read it. I think it's important because the department's counsel went through a litany of exhibits, and we would like to get some testimony regarding those exhibits.
Okay. Right. So I think the exhibits may have some personal information in them. So why
Indeed.
don't we take a break? Do you have a way to email the brief to Mr. Belgarde?
He is in possession of it by email.
Okay.
Just, I believe a few minutes ago, I emailed him the reply brief.
Okay. Does he need to take a minute to take a look at that, or it looks like we may have lost Mr. Belgarde, so let's just wait for I think yeah. So if Mr. Belgarde has a copy, and I think we can try to contact him, just let him know weren't quite ready to take that break yet, or to see if he got disconnected. But okay, thank you. So the panel we all have a copy of that, as well as CDTFA. So if you just want to refer to, for example, Exhibit A, line 3, it says blah, blah, blah. Would you like to address that? We are able to follow along, so there's no need to actually show it on the screen.
Sure.
And so if he has a copy of that, and I think that probably would be the best way to proceed.
Thank you.
Sure.
I would agree with that. And thank you for the offer. I don't see Mr. Belgarde on the hearing currently.
Yeah, it looks like they're trying to contact him. He might have dropped off. So we're just I'm just gonna wait for a minute. My staff, let's take a break. about 5 minutes or so. We're just gonna give the our team time to contact Mr. Belgarde and see if we can get him back on. So we'll come back in a few minutes when we've got everyone here. It looks like everyone is back. Thank you. We are back on the record. It is 3:18 p.m. Mr. Borbeau, since Mr. Belgarde missed some of that, are you okay with proceeding where we left off? I don't think you had officially started your presentation yet.
Yes, and if I could just explain to Mr. Belgarde where we did leave off. I did send him
Oh,
the copy of.
I'm sorry, Mr. Borrow. I'm sorry to cut you off again. I
Mhm.
think before we went on break, Mr. Prasad had indicated that he had a question. Did you have a question, Mr. Prasad?
Oh no, Rick had just told me his internet had dropped off, and I was just trying to communicate that.
Okay, thank you. Okay.
Thank you.
Now, Mr. Borbo, I think we've covered everything, so please go ahead and proceed. You can update Mr. Belgarde and proceed with your rebuttal.
Very good. And how much time do I have, Your Honor?
About 10 minutes or so.
Okay. Mr. Belgarde, Rick, we're going to go through some of the department's exhibits really quickly. Okay, so are you able to bring up the department's response, the copy that I sent you?
Yes.
Okay, and hold on one moment, trying to bring it up myself, and my cursor went away. Okay, man. Oh, this is why I prefer a good old in-person hearing. Okay. Um, Rick, I'm directing you to the department's
If possible, can you just tell me what page?
yes, looking for it now. It will be, I apologize, I had it up here. Okay. So yes. So on the PDF, it is page 26.
Okay, I think I'm on page 26.
Okay, and I apologize now. It's page 27, Exhibit 1. This is the State of California Secretary of State statement of information that we um, went over in your original testimony, but as it was presented by the department in their presentation, I want to cover it. This statement of information naming you as a part of WDFA Ventures and WDFA Marketing Inc. Was filed. There are two dates on it: January 28, 2010, and March 11, 2010. Those dates, do those dates predate your departure from those organizations? Okay. And moving to application for seller's permit, page 29, naming you as president. The date on that document is, I believe, there's a date on.
7/8/2010.
Yes, I have, sorry, oh, okay. Yes, and that date would, according to your testimony, predate your departure, correct?
Yes.
Okay, the sales tax return, page 31, is for the period 8/1/2010 through 9/30/2010. This would have been, and it says it's submitted by you. Take a moment and read that. Would this be at least partially during your tenure at the organization?
The transmission was done on 10/27/2010. That was after the departure, but I can see that this was submitted online and they could put any number, any name in there.
And if you remember, can you recall whether or not your name might have been associated with that account on the online portal?
Most likely, but you actually have to type this in.
Okay.
So somebody has to type in the name and put that information in.
Is it your testimony that you believe somebody might have done that on?
Yes.
Okay, somebody other than you.
Yeah.
And why is that?
Because that's after the date. Even though it's 9:30, it says right here transmission date of 10/27/2010.
Thank you.
And it
Which
looks
is,
like somebody paid it. It looks like it says payment amount of $1,273.
but that would not have been you.
Yeah, I was not.
Okay. And then I have a Quizno Placerville collections document dated, this is page 34. I'm struggling to see the date on it, but I would assume there is a date on it. Okay.
I'm blowing it up and I don't see a date yet.
Yeah. So are you familiar with this document?
No, no, it
Okay.
doesn't look familiar, but it's been a long time.
Okay. And the exhibit exhibit 6, I believe, page 35 appears to be some EDD wage history for WDFA Ventures 2 LLC without a date, with your name on it. Does this document look like something you created or had anything to do?
No, I didn't create this. And the fact is, once again, this is electronic.
Yes, thank you. And moving to page 36, a September 9, 2010 business license application. Please
That's
take a
me.
look at that.
That's me.
And was that during the tenure of your
Yes.
involvement with the business?
Absolutely.
And we already covered the checks in your testimony. So this check is going to page 37 is, oh, that's one of the checks it issued.
Yes.
That's what,
Yeah,
yeah,
yes.
that we've covered that. Okay. Quizno's application, page 38. Date on that is 8/14/2010.
Yeah, that's me.
Okay, thank you. Moving past the rest of the Quiznos application to still going to the Terminix Commercial Pest Control Agreement, which is let's find a date because the date of the fax transmission may be quite different than, well, no, it's okay.
Says projected start date September 2010.
Yes.
So it was right around when I was leaving.
Okay. And do you recognize the number at the top, the fax transmission, the phone number? 415?
That is not our fax number. That would have been a main number.
Okay. All right. But there is a date on it, August 16, 2010, 2:46 p.m. Do you see that?
Yeah.
And would that have been while
Yeah.
you were still involved in the organization?
Yes, if it was
No.
before that, yes.
And no dispute there?
No.
Correct? And moving on to System Services of America, we have a document offered as Exhibit 12, dated 8/17/10. Do you recognize this, and was it during your time?
Yes, it was.
Okay, thank you. Moving past those related documents, responsible person questionnaire. And this, do you recognize this? This was ostensibly filled out by you. I believe you've already testified that was sales tax reimbursement collected, and you testified.
Is this one that's done by Jason Hilton?
No, I don't know. It's got your
Says,
name on it.
says right
Oh, it
there, it
is. Sorry.
says,
Sorry. It is Jason Hilton. Sorry. So
yeah,
we'll move on. You're absolutely right. I saw your name on it and thought it was yours. Let's move on to the next exhibit. That is, okay. So this one is Raj.
and
This is, yeah.
there's a reason why he would try to blame somebody else is because he didn't want to be held responsible. Jason Hilton.
Is that your opinion?
That is a fact because as Raj noted earlier in testimony, he had nothing to do with it. It was Jason Hilton who was basically in charge of that staff
Okay.
until they ever find somebody else. I don't know if they ever found anybody.
But it's true that you're guessing as to Mr. Hilton's motivations, right?
True.
Yeah. Okay. Do you have anything else to base that on? Had he made any statements previous regarding, animosity toward you, bad
He
feelings?
called me up once with Raj to ask if he could get a loan from me to pay the IRS debt because he didn't want to pay it at that point. And Raj ended up paying everything, and Jason didn't pay anything, to my knowledge. So yes, he of course he wanted to get out of it.
Okay. Now, I have going to page 63 of the PDF, Exhibit 21, Department's Exhibit. It appears to be a document purporting to be the business questionnaire with your name on it. It looks like your squiggle signature at 5/23/2014.
The rest of it is my handwriting. I recognize it.
Okay, okay. And you indicated that number one, I did not know if it was sales tax reimbursement collected. Assets, how you were associated. You pay for your services. I believe that's all the relevant information there. We have more case notes offered by the department. I think we're almost done, Your Honors. Let's see. As far as anything that Mr. Belgarde can testify to, let's see. Cash receipts, okay. I believe that is all the redirect I have for Mr. Belgarde regarding the department's submission of exhibits relevant to him.
Okay. So it looks like we are ready to conclude this hearing.
I do have a question, if I may pose it to the panel regarding follow-up to this hearing. If we are able to access any other records, do we have the opportunity to submit those post-hearing, such as minutes, anything that we find might help the panel arrive at their decision? Can we please ask for leave to submit such documents? We don't need to follow it with an extensive briefing or reply schedule if it pleases the panel. Thank you.
Okay, so generally at this point, we would be closing the hearing. But if you think you can access some additional information, that is one of the things that we had asked about earlier. So what we can do is we can leave the record open for 30 days for you to obtain this information. Should you find that information and submit it, then we would give the respondent the 30 days to respond, and then at that point we would close the record. So, okay. So we are going,
Ms. Ralston, I just would like to point out that the department would object to any submission of evidence at this point, given that it is after the due date that evidence was due, absent a showing of good cause as to why it wasn't provided by the evidentiary due date.
Yes, and I have good cause. If I can at some point make a reply.
I'm sure.
Yeah, so the good cause is Mr. Prasad testified today of the possible existence of documents that might be helpful in this case. We had no way of knowing Mr. Prasad was at all in possession or could possibly find these. I think they're material to the issue. It was actually in response to a question posed by the panel. So I think we meet good cause.
Thank you. I think what I would like to have you do is we'll note CDTFA's objection, and when if you are able to obtain the additional information, Mr. Borbell, if you could include your statement regarding good cause. With that information, we'll give you 30 days to get that information and provide it, and then OTA will issue a ruling on that. Should we accept the additional information, then we would give CDTFA a chance to respond, and then we would issue our opinion after the record closes. OTA, the panel will meet, and we will issue a decision within 100 days after the record is closed. I think that concludes this hearing. The next hearing will resume tomorrow morning at 9 a.m. And we'll send out some information going over what we discussed today about the additional information. And I think that is it. So yeah, we'll send out some post-hearing orders explaining what we talked about today regarding the good cause and the additional information. Did you have a question?
Oh, I do, Your Honor. If I could just make a short 3 or 4 sentence statement in response to the department's position. I think it's helpful. If I may be allowed, I believe I have some time.
Sure.
Okay, thank you. So the department stated in essence, not exactly, but I heard the words appellant doesn't have any evidence. I think that it's important to note that the hierarchy of evidence is hearsay statements at the bottom, and then supported hearsay, and then direct testimony. We've provided direct testimony today. We've provided hearsay statements throughout the record with support. And I would remind the board to please, we implore, not remind, we implore the panel, that is, to review regulation 30214 sub F5, which states, after weighing the evidence, the panel will make any necessary factual findings in any opinion issued by the OTA. A factual finding on any material disputed fact shall not be based solely on unsworn statements made by a party during the appeal proceeding before OTA, such as statements contained in a party's brief or arguments made by an unsworn representative during an OTA oral hearing. And I think that's very, very important here. We have evidence. We have very good evidence. We have sworn testimony, live testimony, subject to cross. The department chose not to even cross the witnesses as to the veracity of their statements. So I assume they're accepted for for the statements made. It can't be said enough that this entire thing is hearsay based on estimates and then applied to Mr. Belgarde. It's unfortunate. I think it happens too often. And I really wish it didn't, but here we are. We've got two gentlemen who have, one who's maintained throughout and spent a lot of money to defend his name. The other gentleman, his former business partner, who came here at personal cost to support these statements under oath. I would remind the department that that is evidence. Evidence isn't necessarily something that somebody wrote in the course of their job. It could be factual. We don't know. That person isn't here to support those statements. So they remain hearsay. They should be granted very little evidence. I've seen nothing compelling to think otherwise. Yes, I'm sure Mr. Villasenor is a great guy. I've actually worked with Mr. Villasenor on other cases. In this case, it's not enough. The department has a burden to prove. A burden to prove. It can't be made with hearsay evidence. It's right there in subsection F5. Can't be made. It can't be based solely on unsworn statements. Thank you. We rest. Thank you for your time, panel. I hope that we can come to some resolution in this case, the accurate resolution, which is that Mr. Belgarde just simply wasn't there. Thank you.
All right. Thank you, Mr. Bourbeau. Okay. I think we are ready to conclude. So as I mentioned earlier, we are going to submit post-hearing orders, which will explain about the information to be submitted, and we'll have the deadlines and such for that. This case, okay, so we are going to conclude, and the next hearing will resume tomorrow at 9 a.m. So thank you, everyone, for attending. And yeah, I think that's it. Thank you, everyone.